to the EULA to say where that actually lies within that. And even doing that, again, playing devil's advocate on both sides, if I'm, the provider, I'm going to stretch that as far as I can. This means this. This means also if you're doing nefarious activity, which could, go downstream, I'd like to say I have a role in that, but then you say, okay, well, wait a second. Then what are you doing for all this peer-to-peer stuff? What are you doing about all this porn stuff? They'll say, oh, no, that ain't my problem. So you see where, again, 2 attorneys in one town, a real good living. Yes?
To host systems at Amazon, can I defend those systems that I own in the Amazon cloud, but I really only rent them as a service? Has there been any cases on that?
Not yet.
That's going to be
Oh yeah, that's what we're. The legal talks that deal with cloud computing, and security from that aspect, and what we're looking at for that. I'm sorry, you guys are keeping us in business. If you can fix this whole thing, you can put a lot of lawyers out of business, but they're really going nuts with those areas right now. Acceptable use policy and wiretapping. You're, again, from a private aspect, private employer aspect of life. Government network. All right, let's 2 things, aspects of it. There is model language, banner language for the government. It was written up by the Cyber Lawyer Working Group. And it was put as part of the Einstein 2, which is an intrusion detection system that's being rolled out to different departments and agencies. This is the fun aspect of life, of where I'm standing. This is publicly available information. I'll admit. I didn't publicly go out and get it, although I did on some of it. This stuff I did publicly go out and get. But as part of that aspect of the model language, it is getting rid of my slide back there of that expectation of privacy. So basically, it's my acceptable use policy, and that banner that comes up there is getting rid of that expectation of privacy, so I don't have a wiretap violation. It is prohibited to intercept communications, and if you look at the statute, God bless you, because we're talking oral, wire. It's just the words that lawyers use putting these stuff in here to make sure it's inclusive of it is anything basically you're getting there that's going across a wire or wireless. You can't intercept it. You're prohibited unless you fit under one of the exceptions on why you can. Again, this computer network security is 2511, little a, little I, or little 2, little a, little I. And that's how we do it for computer network security. Again, same thing for a private company. I put it in my acceptable use policy, my banner, and I go through it, and then that's how I'm basically getting it. You've heard about Google. Small company, misspelled. They recently, apparently, this is all New York Times, as a matter of fact. So they recently contacted the NSA for help because they had a problem, apparently. And when they contacted NSA, New York Times reported that they have no statutory authority. Where's this fun, handy-dandy little thing? You guys are probably already there reading anyways. They said NSA has no statutory authority to investigate domestic criminal activity. And said DHS does have authority. That's true, but it's not true. I'm not aware that DHS has authority. Well, as a matter of fact, I'll say DHS does not have authority to investigate domestic criminal activity. The Secret Service, which is under DHS, and somebody else do have that authority. Customs, Border Patrol, things of that nature. But the gist of it is, when a crime happens to a private company, who are they supposed to go to for help? And in this message here, they said NSA doesn't have the authority for that. So they developed a cooperative research and a development agreement. I have to look because we always call them CRADA, is what it's called. And a CRADA is used in government a whole heck of a lot. We used them in the Army a whole bunch. And it's to do research between a federal government and a private corporation, usually laboratories, to develop some research and some technology. So that's what they're using up at NSA. And that's all I'll say. Cert authority. This is the statute for the U.S. Cert. Not many people know that. Not many people look at it. Not many people have read it. It was written before the Cert was even around. It dealt with a entity that was within GSA, and when DHS was stood up, this authority was transferred to the U.S. Cert. The U.S. Cert has been recognized as this entity by OMB, and they're supposed to provide technical assistance to operators of agency information systems, do vulnerability threat alerts to departments and agencies, and that gets situational awareness. That's what they're supposed to do by statute. That's it. No remediation, no jump out and go help. Now, technical assistance, yeah, if I get asked by a department and agency, they can go out and do that. Now, departments and agencies, however many there are, there's supposed to be 12 to 15, department of this, department of that. Yeah, you get subcomponents, 100 or so, have CIOs. CIOs are supposed to do this for the executive head of the agency because they're in charge. The executive head is supposed to do cybersecurity, and the CIO is supposed to do it for them. If they don't ask for help, they're not going to get it, and that's another aspect. Now, there are things called PDs, presidential directives. The last word in this is very, very telling. When you're talking about authorities, there is one authority and only one authority in this land. Statutes, laws. There's the big constitution above that kind of drive everything down. But the only positive authority to do something in this government is statutes and laws. But from that, you get a lot of executive orders and presidential directives that say, you have this statute, do this way. And so this is the PD that basically says, U.S. Cert, get involved with the private sector to help them out. If they want to come to you, if they want to ask, this is how you can get involved with the private sector. Now, an interesting aspect on this. One of the big problems here is the FAR, Federal Acquisition Regulations. Because if you are a prohibited source, meaning if you're a private company that does business with the government, I can't give you a competitive advantage. So if you're going to bid on contracts, and part of the evaluation is, how's your IT infrastructure? How's your security in that? And you've just come to me and reported a big flaw. I come out there, I help you patch it, do it, and everything. And company B over here has the same flaw, and they don't have that information. I've just given you a competitive advantage. Is this frickin' retarded or what? So, if I make that information publicly available and level the playing field for everybody, so everybody's got the same information so they can fix it, I'm good. How many companies are going to let me do that? Now, there's a way to minimize it, to take the company name out, but then again, think of the people you hang around with after work, sitting at a bar when you've got your laptop up and you're eavesdropping on other people's communications going on there, checking out their wireless routers because you're all using the same Starbucks open network. You're all the same company. So all the companies, so you sit there and minimize the information. It's very hard to get anonymity when everyone's talking about it and everybody knows who that happened to. Oh, so back to my positive statute, my positive authority. Hey, there's somebody in the world that has positive authority to investigate computer crime. Whew, it's the FBI. Okay, that's all we need to say about that so I can keep my job. So, now I've got a private company, unclassified network, non-national security system. Is there a duty to report a computer security incident, a computer security intrusion, or a computer security attack? Do I have to report? If he stood up right now and slapped me in the face, do I have to go run down, that's assault and battery, do I have to run down to a cop and say, I got slapped in the face, I'm reporting it? There is no, in this circumstances, there's no affirmative duty to report a crime. I'm not talking about FISMA requirements or government agencies reporting anything to the cert. I'm talking about a private company, unclassified, non-national security systems. I don't have to report it. I don't have to tell anybody. And if you don't think that happens a lot, I'll go for that. So, what's supposed to happen? Well, here's the aspect of it. You saw the information up there in terms of who had what authority and where. When a private company and something happens to a private company, I can't dictate who they're going to go and ask help for in the government. Yes?
Just one also. They do have to report it if data compromised or crime information.
Okay. Yeah. Different aspect. Okay. From now.